deliberately misquoting me,
this is not a
to his advantage. The powers under Article 157(4) of the Constitution is given, in fact, it's the only power, the rest are mandates. The power of the DPP under Article 157(4) is to direct the Inspector General of Police to carry out investigations into alleged criminal activities. That cannot amount to supervision. In fact, to confirm that, you read Article 245(4) of the Constitution, which... Sorry, Your Honor. The law in me is...
Be careful, you might be sick of that. Be careful.
So, Your Honor, the supervision of the National Police Service is elsewhere, not with the ODPP. And like I've assured, I think this is in an assuring manner. We are not an appendage, and we are not a conveyor belt of charges. For us to come before you today, as already indicated, a decision to charge was made in accordance with the Constitution. The Office of the Director of Public Prosecutions Act number 2 of 2013. The ODPP decision to charge guidelines, on which the only test required of the Director of Public Prosecutions, or those of us exercising delegated authority, is whether or not there is evidence with a realistic prospect of a conviction. We may have been wrong in making our decision all right, but that determination will be made by the trial court. And that's why we have presented charges before you. We shall be expected to bring evidence.
Your Honor, if I may, and we do not want to interject our colleagues. With the kind permission, Your Honor, and just to save the court's time, and my colleague comes from my region, so we want to speak a lot, but there is no question about their power or the decision to charge. We do not challenge that. That is theirs, absolutely theirs. The question that is before you is that affidavit that denies them bond. They've already taken plea. We are okay with that. We'll deal with that. But the issues that we believe the court is interested in is the issue of whether there are compelling reasons. And he's avoiding that because there is no compelling reason.
Your Honor, I have that as my next issue. The court was here when a lot of arguments were made on why the office of the DPP has perpetuated an illegality, has violated the Constitution. We have a right to respond to that. That's actually why we're representing the ODPP here. That accusations were made against us. So just like we were very patient with the council, let them be very patient with us. It is very important to us, just like it is important to their client's case. So I plead with this court to allow me to respond to all the issues that they raised. And I'm almost done.
The next point.
Our next point is on the question of Article 49, on whether or not there exist compelling reasons. And Your Honor, we started with the question of jurisdiction. To guide this court with humility, that is the only question that arises for your determination. Not the 98% of the submissions from the defense. You know, first of all is the technical question about whether or not the affidavit is dated. It is not. However, a look at page 2 of the application makes reference to the deponent of the affidavit. Page 2 of the application. It identifies the deponent of the affidavit, and the affidavit speaks to the grounds in support of the application on the same page, page 2. Those grounds are 1 to 4 on the face of the second page. And finally, on that page 2, the application is dated. We therefore invite you to invoke Article 159 because the affidavit is stamped duly and it is signed. Invoke Article 159(2) and find it proper. For the avoidance of doubt, no application was made to you to strike it out. To the substance, when you retire, Your Honor, you are going to ask just one question. And that's probably what should have come from the defense, and we should have responded to in rejoinder. Whether or not the prosecution has established any compelling reasons to deny any of the respondents' faith. I reiterate the submissions of my learned senior on the contents of the application and the affidavit. Only to further refer this honorable court to clause 4.9 of the Judiciary Bail and Bond Policy Guidelines. Clause 4.9. And more specifically, 4.9c on character and antecedents, 4.9e on possible interference with investigations, and 4.9g on possible interference with witnesses. Those grounds are again on the face of page 2. Just before we go to page 2, the prayers on the application, and then on page 2 we say the grounds number 2, number 3, and number 4. Likelihood of interference with witnesses at ground number 3. Likelihood of interference with ongoing investigations. And finally, the possibility of committing similar offenses, which goes to antecedents. Where do we get the facts? My learned senior, Mr. Awele, asks the question, whose reasonable belief? The belief is of one Corporal Geoffrey Mwangi. He identifies that belief in the affidavit, as should be done. What is the source of the belief?
Your Honor,
identifies.
with your kind permission. Your Honor, this is usually not my ordinary playground, and Mr. Whitty knows it. But I believe the rules still apply. He is supposed to be limited to questions of law in his rejoinder. Yes. And I think it is unfair for the accused people for him to start raising or making allusions, factual allusions, that we will not have an opportunity to respond.
On that basis, because I was silent awaiting for the opportunity to raise that issue, and Mr. J.V., learned counsel for the DPP, when addressing the question of the pre-arraignment detention, he did not direct you to look at the charge sheet on the date of the arrest, which is the 18th, and the date of presentation to court, which is 20th. I thought it was important for me to point out.
Yeah, maybe I
No
can
explanation
address
has been,
that last.
and no explanation has been offered. They never disclosed, and this is their charge sheet, unless they are denying it.
That's okay. Your will address that last. I was concluding on the issue of whether or not there's compelling reasons. We invite you to look at. Sorry, Your Honor. Sorry.
The issue that Mr. Owele is raising.
Owele.
Yes.
Is very critical.
It is the reason that I have said I'm concluding on that issue so that I don't go on the issues of facts. I think that was guidance.
Yes.
I am very well guided. And in conclusion, we invite you that when you retire and look at the matters of fact on the affidavit vis-a-vis the prayers in the application, you find that indeed there has been established compelling reasons to deny it. There are two questions of law that are left, which I conclude with. Edwin Shisanya Amboso versus Republic is a decision of the Honorable High Court, Justice Mugambi, that you've been referred to. We have agreed, and it makes sense, that there is a distinction between the orders granted in Edwin Sishanya, which rejected an invitation to declare assemblies unconstitutional or to issue conservatory orders to that effect. The charges before you are in